day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk. If you haven't done so already, please hit that subscribe button. If you've already done so, that's wonderful, but hit that little bell so that you receive notifications when we go live or put up new content. First on the docket today, some comments regarding Chris Watts. And I know a lot of people are tired of Chris Watts, and other people cannot get enough of Chris Watts. But the reality of it is, I don't think it's going away anytime soon. Based upon some of the comments that I have seen, some of these people, I do not know what world they are living in. First, we read to you directly from the transcripts, which clearly states in the colloquy between the judge and Christopher Watts that he is pleading guilty and he stipulates to those facts. There are some people out there saying, it's no good. It wasn't under oath. I can tell you, as a practicing attorney who's practiced for 20 plus years in the state of Colorado, I don't think I've ever done a plea in the state of Colorado where the defendant is placed under oath. Now, in the federal system, they do, and they tell you, if you give me false statements, guess what? I'm going to prosecute you for perjury. But it's still the same thing. If Chris Watts were to come in and say, let's say a judge says, fine, I'll give you a hearing. The first thing the prosecutor would do would simply be, Mr. Watts, didn't you say this? Didn't you say this? Didn't you plead guilty? You said that you were doing this of your own free will. You were happy with your attorneys. Oh, you lied then? So why should we believe you now? Not going anywhere. He's going to stay in jail the rest of his life. He's not getting out. I even had people say, well, it was an illegal sentence, therefore he gets out. Don't think it was an illegal sentence, ladies and gentlemen. There were at least 3 counts of pleading guilty to first-degree murder. Then there were counts related to the children being over 12, sentencing enhancement counts, and then the tampering and etc. He's never going anywhere. And let's just say, for the sake of argument, that there was a mistake made where something should have merged, or there was a consecutive sentence that maybe shouldn't have been imposed, but the court easily could do that. Guess what? Then you go back and you correct an illegal sentence. But that does not mean that the whole case or plea is withdrawn. Completely makes no sense. And these people that I don't understand. If you want to go root for an underdog, go root for somebody who has maintained their innocence from the beginning. Actual innocence. Chris Watts confessed to the police. He confessed to the police up at the Dodge Correctional Institution. And he has all but done so to other people. Why can't this just go away? And don't get me wrong, my channel basically started because of Chris Watts. But even, yes, it's time to move on to new cases. Next on the docket, Ghislaine Maxwell really wants to go home. Now, we told you about last week that the prosecutors were writing letters to the judge saying that no relief should be given to Ghislaine Maxwell, and no hearing should be held regarding a bond reduction because her bond has already been set and it's already been found that she is a danger to the community and a flight risk. Now, you have to give Ghislaine Maxwell some credit for her persistence, and her attorneys are trying to say that, hey, judge, we are providing new information. First, the new information has to do with her financial situation. She had some very unique financial resources available to her early on in this particular case. And the district attorney said, we don't know exactly what's going on. Therefore, we think she has the resources to flee the country and never come back. So don't give her bond. That was one of the reasons. Well, Ghislaine Maxwell is apparently turning over, not to the public, but to the court under seal, a financial accounting by her CPA to show what she has and what she doesn't have, and apparently what is available to secure a bond in this particular case. Now, the United States attorneys have also objected to the allegations that somehow Ghislaine Maxwell is being mistreated. Apparently she is out of her cell for some 11 hours of the day, which is a little bit contradictory to what the attorneys were saying, that she was basically in lockdown and being awoken every 15 minutes to make sure that she has not harmed herself in any way. The Bureau of Prisons completely denies that whatsoever. Now, this filing that was made under seal told the judge that they were relying upon sensitive and private information, and if it were made public, it would be highly damaging to both Ms. Maxwell as well as third parties, in part because the third parties would be subject to harassment and media scrutiny. I'm not sure, obviously we don't need people harassed, but being subjected to scrutiny is not necessarily a bad thing. That's what helps bring out the truth. We'll see if the judge denies the motion on the paper, the filings in the case, or if they actually set the matter for a hearing. And if it does, we'll let you know about it. Some truckers had a real bad night, but I think we can probably figure out where this is headed. 2 truckers died and another was left critically injured after being tied up, tortured, shot, and dumped in the city of Opelika near Miami in Florida. Osmar Oliva, 50 years old, and Johan Gonzalez Quesada, 26, were beaten, shot, and dumped in the backyard of an abandoned house, according to police. A third man, whose name has not been released, had been beaten and shot, but has survived. The 3 victims were found tied up on the 1800 block of Rutland Street on Saturday evening when the officers from the city of Opelika found them at the scene. The surviving victim was airlifted to Miami-Dade Airport, where he is with the trauma unit. Right now, there are no apparent suspects. What's interesting about this is in 2007, Oliva was reportedly arrested when officers claimed he was one of the 3 men found unloading cargo off a stolen tractor trailer that had been located using a GPS device. Meanwhile, in 2019, Gonzalez Quesada was accused of having 2 loads of pilfered cargo, frozen shrimp, and air conditioning units that had been traced via GPS or stolen tractor trailer information. This is speculation, I want to tell you that. But my guess is that they may have taken somebody else's trailer and they weren't happy about it. Now, obviously, justice needs to be done here because you can't go around beating up things. But a teachable moment comes from this, which is you may not want to take other people's things. Now, like I said, that is just complete speculation on my part. But I think I'm going to be right on this one.
Chad Daybell's attorney makes his written argument as to why he believes that there should be a change of venue. So John Pryor, the attorney for Mr. Chad Daybell, has stated and had filed a very generic motion early on stating that he wanted a change of venue because there's been pretrial publicity. Well, he filed a brief and it basically says that the venue should be changed because a fair and impartial trial cannot be held in Fremont, Madison, or Bonneville counties. And his initial brief goes on to basically say that everyone is entitled under the United States as well as the Idaho Constitution to an impartial jury trial. It's guaranteed by the 6th and 14th Amendments to the United States Constitution, as well as the applicable sections of the Idaho Constitution. Now, there's some little bit of law cited in here, which kind of sets the standard, and you really have to look at each case on a case-by-case basis. However, when you get to the meat of the argument, a lot of it is there's so much speculation going on about this case. And he basically says, hey, the DA could clear all this up if they would just release some information. So let's talk about it. To support this assertion regarding a change of venue, he says that there is inadmissible and inflammatory evidence that has been an overwhelming amount of it reported as it relates to Miss Vallow's activities in Arizona prior to any relationship with Mr. Daybell. Articles and audio recordings of Miss Vallow's insinuating her right to cause harm to her third husband, a video recording of a material witness expressing her view on the case, additional inflammatory and untruthful information that has been reported by local media insinuating that Mr. Daybell had some role in his wife Tammy Daybell's death. Mr. Pryor states in his brief that it is the prosecutor who continues to allow this inaccurate information to continue by not providing the autopsy results performed on Tammy Daybell, despite it having been performed a significant time ago. The advancement of this narrative in a small population area only continues to taint the jury pool, according to Mr. Pryor. Mr. Pryor goes on to state that He has not granted any public interviews related to this case, has not given any statements to the press for publication. He then states that rather, counsel for Mr. Daybell has purposely and intentionally kept quiet even when the media continues to report facts that the defense takes issues with. The prosecution through the county has employed a public relations firm to handle all media requests and comments directed to the county. Information to defense counsel suggests they are trying to advance their own narrative of the case. The special prosecution, Fremont and Madison County officials allowed ribbons to be placed and ribbons posted upon the courthouse and government property until Mr. Pryor brought it to the magistrate court's attention, at which time they were suddenly removed and the public relations firm was retained. Mr. Pryor goes on to state that the communities in Fremont, Madison, and Bonneville counties are predominantly Latter-day Saints communities, and although religion in no way qualifies anyone to serve on any case, at the direction of the, and I'm not sure what this is, a stake, S-T-A-K-E president in Henry's Fork, Mr. Daybell's sister sent a mass email to all the ladies within the Henry's Fork stake, only causing greater concern that any potential jury pool would be tainted. There was a request of the Henry's stake president to Mr. Daybell's sister to communicate to all of the ladies within the stake regarding the facts as she sees them. It should be noted that in the discovery provided to the defense counsel at this point, it does not show that Mr. Daybell's sister had any personal information or involvement in this case. Rather, it's been suggested to the defense counsel, Mr. Pryor states in his brief, that through investigation that he is related through marriage to law enforcement who may have had an investigation role in this case. This, of course, causes great concern to Mr. Pryor and states that her assertions in her email to all of the ladies of the Henry's Fork stake that she has personal knowledge of the facts. Now, although defense counsel has no evidence, is what Mr. Pryor states, he says he has no evidence provided by the prosecution that Mr. Daybell's sister has information or evidence in this case. There is no information regarding her connections through marriage to law enforcement. He further states that he has no direct information that anyone in law enforcement has spoken to Mr. Daybell's sister. Mr. Pryor has great concern that law enforcement in this case is speaking or has continued to speak to members in the community about the facts of the case. He further states that the continued untruths that somehow Mr. Daybell is involved in some sort of cult activity continues to be presented to the local community. Although there is significant reference to the LDS scriptures and religion, the suggestion of cult activities is continually being advanced without any merit. The survey presented to the court, performed by defense counsel and provided as an exhibit, supports the assertion that a fair trial cannot be had in the 7th Judicial District. It shows that not only was the person who was conducting the survey received threats from Bonneville, Madison, and Fremont counties, that the vast majority of the people interviewed stated that they have already made up their mind regarding the guilt of the defendants. Further, the vast majority would not change their mind, basically, if they were to hear new evidence. Now, Mr. Pryor then goes on to take some shots at the East Idaho News, who he describes as the dominant and expansive newspaper with readership within all of the 7th Judicial District, has on almost a daily basis reported on information regarding this case. It's published interviews with material witnesses to the case, published numerous pictures of the location where the bodies were discovered, photos of the courthouse laced with ribbons and pictures, and Mr. Pryor has also submitted photos of businesses and places within the 7th Judicial District expressing their opinion on the case. Now, considering the pretrial publicity and the strong feelings in the community, Mr. Pryor believes that the court should take the appropriate steps to protect Mr. Daybell's right to an impartial jury, in addition to moving venue to a larger population within the state. He further requested a jury questionnaire be submitted so that we can inquire of who of any potential jurors had been exposed to pretrial publicity. So Mr. Pryor's brief kind of lays out what you have to be able to show on a change of venue. Now, I wish we could see the actual report based upon the survey of people that were interviewed within the counties and that are referenced in the brief. That is going to be the most telling. What was the population polled? How many had already formed their opinions, and if they're not going to change their minds? The issue the court's going to have to decide is, will this affect a fair trial for Chad Daybell and Lori Vallow? What it boils down to is, unless the court is so convinced by the survey that was conducted on behalf of the defense, the judge may just wait to see what the potential jurors say in voir dire, which is the jury selection process. Certainly in those counties, they're going to have people that have heard about the case. There may be people that have read every piece of news out there about the case. The reality of it is, though, it doesn't mean that you can't get a fair and impartial trial. I had a very similar case. It involved the death of two small children in a case. It was very widely published, and the county in which we were in, the court moved, changed the venue, but she kept it within her judicial district. And in that judicial district, we were able to bring in hundreds and hundreds of jurors. And guess what? We were able to find 12 plus 3 alternates who had never heard anything about the case, who said that they could listen to the evidence and reserve judgment until they hear all the evidence and then be given the law by the court. So it's possible. The court in this particular situation is going to have to make its own call. The judge is going to live in this jurisdiction. He is going to know and have the best feeling as to what's taking place. And if he truly believes you're just not going to get a fair trial, he should just move it. Don't delay it. Just do it. Now, one of the other points that I want to comment on that John Pryor made in his brief is that the district attorney has the autopsy result as it relates to Tammy Daybell, Chad Daybell's wife, who passed away, and then he just happened to marry Lori Vallow 2 weeks later and then go off to Hawaii. If the prosecutor has that report, he has a duty, in my humble opinion, to release it. But to manipulate the situation and try to create that Lori Vallow is some black widow as it relates to the death of her previous husband, or even as it relates to Tammy Daybell, he should release it. The public is entitled to the facts. We're all big boys and girls. We should be entitled to see what's taking place. If there's going to be an investigation, it can be done. If you're going to charge somebody, charge them, but don't manipulate the public. Don't try to manipulate the system. Release the autopsy result. Let me know what you think. Do you think John Pryor has made a good enough case for a change of venue? And do you think the district attorney should release the autopsy for Tammy Daybell if he has it? I say yes. Let me know what you think in the comments below. On the docket, more motions in the Chad Daybell matter. Now, the other day, John Pryor, the attorney for Chad Daybell, filed a brief in support of his motion for a change of venue. Now, the only thing of real substance in that brief was that apparently at some point, which has not been released to the public, was a survey that was apparently done, which is to show the court that some empirical data suggests that a large swath of the community there has already formed an opinion as it relates to the case. That's good empirical evidence that the court will have to consider. The other information that was included in there was a little generic and general, and basically saying there's a lot of misinformation by the press and the prosecutors playing games and trying to manipulate that by, for example, not releasing the autopsy report of Tammy Daybell. I'm a firm believer, hey, if that report's done and they're not going to file charges, make it public. Let's cut to the chase. Let's cut to the truth. Certainly the prosecutor has a little bit of a motive to try and play the whole Lori Vallow is a widowmaker killing off a series of ex-husbands. And, a lot of people around her just simply seem to die rather unexpectedly. Now, is that coincidence, or have they got probable cause? If they've got probable cause, charge her. If they don't, let's move on. Let's let the facts decide the case. And let's face it, there's a lot of bad facts for the case of Lori Vallow and Chad Daybell that you don't need to bring in all this extra drama. And we've talked about this before in previous videos, where how are they going to get all that other evidence in? It's not relevant to this particular case. It's what they call 404B evidence. It's not worth the hassle on the prosecution. In this particular case, they have a very straightforward case. Her children are missing. She acted like she didn't care. Certainly, if she didn't have something to do with it, a lot of people believe that her brother, Alex Cox, may have had something to do with it. That would be my inclination. But she certainly didn't go around looking for the children or acting very concerned when she got married to Chad Daybell 2 weeks after his wife passed away unexpectedly, who, as far as we know, was relatively healthy and training for a marathon. Those are some pretty good facts. The fact that they went to Hawaii and no children to be found, nothing of the children there to say that they were being cared for, and she has no idea. Let's face it, that's the biggest problem Lori Vallow has in her case. And Chad Daybell, I guess his defense is going to be, I didn't know. I married this woman 2 weeks after. How was I supposed to know all that was going on in her life, other than maybe they were involved, one could say, long before that? So we'll see how things shake out. So the district attorney has served some new motions on the defense, specifically Mr. Pryor. The district attorney is asking for the names, telephone numbers, and curriculum vitae, which is a fancy word for resume, of any and all expert witnesses the defense intends to call at the hearing for the defendant's motion to change venue, and any and all expert witnesses upon whose work the defense to rely on at the hearing for the defense motion to change venue. Why is that? If there was a survey done, which it's been alluded to and apparently attached to, the qualifications of the people doing the interpretation and what they did is at issue. So now we need to find that out. And the prosecution certainly has a right to have that information prior to any hearing as well. The second request from the prosecutor to Chad Daybell's attorney is for each of the expert witnesses or individuals specified in specific request number 1 and the response thereto, the prosecution requests the defendants provide the prosecution with A, the facts or data upon which said expert bases his or her opinions, any articles, report, treaties, book, periodicals, or other documents used, reviewed by the expert to help him or her formulate their opinion upon which she bases their opinion, the substance of any said expert opinion or testimony. This is standard information. Normally, if you're relying upon an expert witness, the court can dictate, but usually most states say 35 days prior to trial, you have to turn over the report, and what they say in the report is usually what they're limited to testifying to. Anything that they're relying upon, any information that they've examined, tests that they've conducted, all that has to be turned over so that you can have a fair hearing. We do know, or possibly believe, based upon the pleadings of John Pryor, that he attached a kind of a results of the survey that was conducted to show that the citizens have formed an opinion in the county, and therefore neither Chad Daybell nor Lori Vallow can receive a fair trial. Now, one thing note about all of this stuff is that, once again, where is Mr. Means? Why is he not filing anything? I think he's simply riding the coattails of Mr. Pryor and Chad Daybell in this particular case. That's probably the best tactic that he has taken thus far in all of these proceedings. Let me know. I know this is kind of a hot issue. Do you think the case is going to get moved, or do you think that it'll stay where it is? Let me know in the comments below. All right, that's all we have for you today. Please leave me a comment on what we talked about, and we will see you next week. Have a wonderful weekend.